bhartiya sakshya adhiniyam chapter 1 preliminary section 1 short title application and commencement section 2 definition 2a code 2b conclusive proof 2c disproved 2d document 2e evidence 2f fact 2g fact in issue 2h may presume 2i not proved 2j proved 2k relevant 2l shall presume 2 words and expression. Chapter 2 Relevancy of Fact Section 3 250 Section 3 Evidence may be given of fact in issue and relevant fact. Relevancy of fact forming part of same transaction. Section 5 Fact which are occasion, cause or effect of facts in issue or relevant fact. Section 6 Motive, preparation and previous or subsequent conduct. Section 7 Fact necessary to explain or introduce fact in issue or relevant fact. Section 8 Things said or done by conspirator in reference to common design. Section 9 When fact not otherwise relevant become relevant. Section 10 Fact tending to enable court to determine amount or relevant in suit for damages. Section 11 Fact relevant when right or custom is in question. Section 12 Fact showing existence of state of mind or of body or bodily feeling. Section 13 Fact bearing on question whether act was accidental or intentional. Section 14 Existence of course of business when relevant. Section 15 Admission defined. Section 16 Admission by party to proceeding or his agent. Section 70 Admission by person whose position must be proved as against party to suit. Section 18 Admission by person expressly referred to by party to suit. Section 90 Proof of admission against person making them and by or on their behalf. Section 20 When oral evidence as to content of document are relevant. Section 21 Admission in civil cases when relevant. Section 22 Confession caused by inducement, a threat, coercion or promise when irrelevant in criminal proceeding. Section 23 Confession to police officer. Section 24 Consideration of proved confession affecting person making it and other jointly under trial for same offence. Section 25 Admission not conclusive proof but may stop. Section 26 Cases in which statement of relevant fact by person who is dead or cannot be found etc. is relevant. Section 27 Relevancy of certain evidence for proving in subsequent proceeding truth of fact therein stated. Section 28 Entries in book of account when relevant. Section 29 Relevancy of entry in public record or an electronic record made in performance of duty. Section 30 Relevancy of statement in map, chart and plan. Section 31 Relevancy of statement as to fact of public nature contained in certain act or notification. Section 32 Relevancy of statement as to any law contained in law books including electronic or digital form. Section 33 What evidence to be given when statement form part of a conservation document, electronic record, book or series of letter or paper. Section 34 Previous judgment relevant to bar a second suit or trial. Section 35 Relevancy of certain judgment in probate etc. jurisdiction. Section 36 Relevancy and effect of judgment order or decree other than those mentioned in Section 35. Section 37 Judgment etc. other than those mentioned in Section 34, 35, 36 when relevant. Section 38 Fraud or collusion in obtaining judgment or incompetency of court may be proved. Section 39 Opinion of expert. Section 40 Fact bearing upon question of expert. Section 41 Opinion as to handwriting signature when relevant. Section 42 Opinion as to existence of general custom or right when relevant. Section 43 Opinion as to usage, tenant etc. when relevant. Section 44 Opinion on relationship when relevant. Section 45 grounds of opinion when relevant. Section 46 in civil cases character to prove document imputed irrelevant. Section 47 in criminal cases previous good character relevant. Section 48 evidence of character or previous sexual experience not relevant in certain cases. Section 49 previous bad character not relevant except in reply. Section 50 character as affecting damages. Chapter 3 fact which need not be proved. Section 51 fact judicially noticeable need not be proved. Section 52 fact of which court shall take judicial notice. Section 53 fact admitted need not be proved. Chapter 4 oral evidence proof of fact by oral evidence. Section 55 oral evidence to be direct. Chapter 5 of documentary evidence. Section 56 proof of content of document. Section 57 primary evidence. Section 58 secondary evidence. Section 59 proof of document by primary evidence. Section 60 cases in which secondary evidence relating to document may be given. Section 61 electronic or digital record. Section 62 special provision as to evidence relating to electronic record. Section 63 admissibility of electronic record. Section 64 rules as to notice to produce. Section 65 proof of signature and handwriting of person alleged to have been signed or written document produced. Section 66 proof as to electronic signature. Section 67 proof of execution of document required by law to be attested. Section 68 proof where no attesting witness found. Section 69 admission of execution by party to attested document. Section 70 proof when attesting witness denies execution. Section 71 proof of document not required by law to be attested. Section 72 comparison of signature, writing or seal with other admitted or proved. Section 73 proof as to verification of digital signature. Section 74 public and private document. Section 75 certified copies of public documents. Section 76 proof of document by production of certified copies. Section 77 proof of other official documents. Section 78 presumption as to genuineness of certified copies. Section 79 presumption as to document produced as a record of evidence etc. Section 80 presumption as to gazette, newspaper and other documents. Section 81 presumption as to gazette in electronic or digital record. Section 82 presumption as to map or plan made by authority of government. Section 83 presumption as to collection of law and report of decision. Section 84 presumption as to power of attorney. Section 85 presumption as to electronic agreement. Section 86 presumption as to electronic record and electronic signature. Section 87 presumption as to electronic signature certificate. Section 88 presumption as to certified copies of foreign judicial record. Section 89 presumption as to book, map and chart. Section 90 presumption as to electronic message. Section 91 presumption as to due execution etc. of document not produced. Section 92 presumption as to document 30 years old. Section 93 presumption as to electronic record 5 years old. Chapter 6 of the exclusion of oral evidence by documentary evidence. Section 94 to 103. Section 94 evidence of terms of contract, grant and other disposition of property reduced to form of document. Section 95 exclusion of evidence of oral agreement. Section 96 exclusion of evidence to explain or amend ambiguous documents. Section 96 exclusion of evidence against application of document to existing fact. Section 98 evidence as to document unmeaning in reference to existing fact. Section 99 evidence as to application of language which can apply to one only of several documents. Section 100 evidence as to application of language to one of two sets of fact to neither of which the whole correctly applies. Section 101 evidence as to meaning of illegible character. Section 102 who may give evidence of agreement varying terms of document. Section 103 saving of provision of Indian Succession Act relating to will. Chapter 7 burden of proof. 104 burden of proof. 105 on whom burden of proof lies. 106 burden of proof as to particular fact. 107 burden of proving fact to be proved to make evidence admissible. Section 108 burden of proving that case of accused comes within exception. 109 burden of proving fact especially within knowledge. Section 110 burden of proving death of person known to have been alive within 13 years. 111 burden of proving that person is alive who has not heard for 7 years. Section 112 burden of proof as to relationship in the case of partner, landlord and tenant, principal and agent. Section 113 burden of proof as to ownership. Section 114 proof of good fact in transaction where one party is in relation of active confidence. Section 115 presumption as to certain offence. Section 116 birth during marriage, conclusive proof of legitimacy. Section 117 presumption as to abatement of suicide by a married woman. Section 118 presumption as to dowry death. Section 119 court may presume existence of certain fact. Section 120 presumption as to absence of consent in certain prosecution for rape. Chapter 8 estoppel. Section 121 estoppel. Section 122 estoppel of tenant of license of person in possession. Section 123 estoppel of acceptor of bill of exchange, bailee or licensee. Chapter 9 of witnesses. Section 1 to 4 who may testify. 1 to 5 witness unable to communicate verbally. Section 1 to 6 competency of husband and wife as witness in certain cases. Section 1 to 7 judges and magistrate. 1 to 8 communication during marriage. 129 evidence as to affair of state. 130 official communication. 131 information as to commission of offence. 132 professional communication. 133 privilege not waived by voluntary evidence. 134 confidential communication with legal advisor. 135 production of title of witness not a party. 136 production of document or electronic record which another person having possession could refuse to produce. 137 witness not excused from answering on ground that answer will criminate. 138 accomplice. 139 number of witnesses. Chapter 10 examination of witnesses. 140 order of production and examination of witnesses. 141 judge to decide as admissibility of evidence. 142 examination of witnesses. 143 order of examination. 144 cross examination of person called to produce a document. 145 witness to character. 146 leading question. 147 evidence as to matter in writing. 148 cross examination as to previous statement in writing. 149 question lawfully in cross examination. 150 when witness to be compelled to answer. 151 court to decide when question shall be asked and when witness compelled to answer. 152 question not to be asked without reasonable ground. 153 court procedure of court in case of question being asked without reasonable ground. 154 indecent and scandalous question. 155 question intending to insult or annoy. 156 exclusion of evidence to contradict answer to question testing veracity. 157 question by party to his own witnesses. 158 impeaching credit of witnesses. 159 question tending to corroborate evidence of relevant fact admissible. 160 former statement of witness may be proved to corroborate later testimony as to same fact. 161 what matter may be proved in connection with proved statement relevant under section 26 or 27. 162 refreshing memory. 163 testimony to fact stated in document mentioned in section 162. 164 right of adverse party as to writing used to refresh memory. 165 production of document. 166 giving as to evidence of document called for and produced on notice. Section 167 using as evidence of document production of which was refused on notice. Section 168 judges power to put question or order production. Chapter 11 of improper admission and rejection of evidence. Chapter 12 repeal and saving.